Bridget McKay here on my next installment of my video blogs relating to planning your estate. Today I want to talk about durable powers of attorney for financial affairs. You may ask, why would I need this document? What's its purpose? Well, this is a document you get when you go to have your living trust prepared. And it's a document that handles all of those things that may happen in your life that render you temporarily incapacitated, which is a nice way of saying, you've been in a car accident and you're in the hospital, you've had a stroke, a heart attack, something that has rendered you unable to pay your bills and conduct your normal financial affairs. Although it can also go to the extent where your agent does pretty much stands in your shoes and can sell your home, can sign escrow documents for you, and in some cases change your trust. So it's a very important document, and its function exists only while you're alive. We've already planned your trust or your will, but this document steps in while you're alive for a temporary period of time, or at least that's what it's intended for. So that's a little reason why you need it and what it does. There are two different types of this document. In other words, I can write it two different ways. I can write it where it's an immediate, your agent, the person you choose to do all these things for you and stand in your shoes, can, the moment you sign it, be your agent, and can even act it for you if you're not incapacitated. I've done powers of attorney for folks who have gone on vacation and the timing was such that they were in the midst of refinancing a home and they needed their daughter to sign all their papers at escrow for this refinancing. So in that case, they used their durable power of attorney. She signed their signature on their behalf, and that was completed and nobody was incapacitated or nothing catastrophic had happened. The second type of power of attorney can be a springing power of attorney, and that is when it only comes into play when you're incapacitated. And typically in these documents there'll be a paragraph saying one or two doctors need to, the agent needs to provide one or two doctor's notes that say you don't have capacity and cannot conduct your financial affairs. So those are the two types. Durable powers of attorney can also be used in more advanced type of planning. They're often seen in a Medi-Cal benefits planning scenario. They're often essential in that realm. It allows your agent, when you're in, presumably in a Medi-Cal benefits planning scenario, you are in a skilled nursing facility for an unknown length of time. And so it allows your agent to gift your assets in order to qualify for Medi-Cal benefits. They can change your trust, and they can do any number of things that would put your financial affairs in a place that you could apply for Medi-Cal benefits. So it does come in handy in that scenario. I will be talking about Medi-Cal benefits planning later in the series, but for now, just know that it helps. Another area of an advanced sort of use for a durable power of attorney is if you have dementia or a loved one has dementia and need to be placed in a locked memory care facility, they won't take you unless you have a durable power of attorney for that loved one. And if you don't have a durable power of attorney for that loved one, then they're going to require you and your family to apply through the courts for a conservatorship. Another sort of teaser for another video blog I'll be doing on conservatorships. And you'll see when you see that video blog that it's a very long, costly process, that if you can produce this durable power of attorney to avoid it, it's worth it, much like a living trust is worth it to avoid probate. So to recap, a durable power of attorney is in place while you who created are alive. As soon as you're deceased, your agents can no longer act on your behalf. It helps in temporary incapacity type situations and can even help in long-term incapacity situations. And its main goal is to for you to designate someone to handle your financial affairs. They come in two forms. You could either have an immediate form. By the moment you sign it, your agent is your agent. They don't have to show any financial institution a letter from a doctor. Or you can have a springing, where it only comes into play when you are designated and incapacitated by two physicians or one physician's letter. I hope that's been helpful. Please look out for our future blogs on healthcare directives, choosing agents, choosing trustees, and the other blogs I've alluded to during this one. Thank you.